on government surveillance as Congress considers FISA reauthorization.
The investment in what we have as a government, we either have to protect or grow so that some of the things that we'll talk about today won't get out of hand. So you can follow me from that perspective. So the hearing will come to order. Good afternoon. Today's Democratic members of the Committee on Homeland Security are holding a hearing to examine the unconstitutional surveillance state under the Trump administration. In the wake of September 11, 2001 attacks, the federal government dramatically expanded its surveillance infrastructure, adopting new tools designed to detect foreign terrorist threats and thwart future attacks. Those tools included systems capable of capturing cell phone signals, collecting large volumes of location and metadata, scanning license plates, identifying individuals through facial analysis, and purchasing detailed consumer information from commercial data brokers. Over the years, there have been an inherent tension between the legitimate security objectives of such tools and the need to uphold civil liberties to preserve a free society. And the tension has not been without basis. As someone who grew up in the civil rights era, I know how government surveillance can be used to intimidate critics, influence political participation, and retaliate against perceived opponents. I remember when the FBI employed its counterintelligence program, commonly referred to as COINTELPRO, to surveil and discredit civil rights activists like Martin Luther King Jr., as well as anti-war activists. So while the abuse of surveillance tools is certainly not new, the Trump administration's use of powerful, modern tools to monitor and investigate Americans and stifle dissent among those who oppose the president's agenda is unprecedented in that it is a brazen and unchecked policy. To facilitate President Trump's cruel mass deportation campaign, the Department of Homeland Security has been rapidly building an arsenal of new spyware and forensic technology. Trump's DHS has purchased mobile license plate readers, cell phone location tracking devices, and surveillance video feeds. ICE has awarded several new contracts to tech companies to find neighborhoods to raid and help officers and agents hack into phones remotely and access both encrypted and deleted data. ICE has also deployed a mobile phone application which questionable accuracy, known as Mobile Fortify, to identify individuals by capturing facial images or fingerprint using a phone camera. This app was deployed in a rush without guardrails and has already proven unreliable. In sworn testimony, an ICE official described an instance where photos of the same woman returned two different identities. Moreover, the Trump administration is blatantly cracking down on Americans engaged in protected First Amendment activity. Legal observers of law enforcement activities have reported being filmed and followed while engaged in lawful activity. In one instance, an ICE officer in Maine can be seen in a video taking pictures of a legal observer's car and telling the observer he was taking the photos, quote, because we have a nice little database and now you are considered a domestic terrorist, unquote. And just last month, it was reported that the Department of Justice is obtaining the names, addresses, financial data, and other personal information on those who criticize DHS's violent immigration tactics on social media. But the administration is not only weaponizing the government's surveillance apparatus to further its cruel immigration agenda, it is weaponizing those technologies to quash all forms of perceived dissident. As a Washington Post journalist wrote about FBI Director Kash Patel using FBI personnel and resources to provide his girlfriend with government security and transportation, Patel used the weight of the world's premier investigative agency to query databases for information on that journalist. In April, Trump's Office of Personnel Management issued a public notice regarding its plan to collect sensitive health information, including prescription and treatment information from millions of federal workers and retirees and their families. If I covered every example of the rampant surveillance abuse under this administration, we would be here until next year. But the point is, under the Trump regime, we are hurtling toward an authoritarian-type surveillance state that punishes dissent and inflicts state violence. And House Republicans are complicit. By voting for the big, ugly bill, they enable the weaponization of surveillance tools against the American people by providing blank checks to law enforcement agencies without establishing any guardrails. They have allowed the dismantling of oversight mechanisms like the Privacy and Civil Liberties Oversight Board. I can recall a time not too long ago when Republicans decried the weaponization of government. But today, when their fellow Americans have their constitutional rights trampled on, all we hear is crickets, not a word from them. But Democrats have been and will continue sounding the alarm. So today, we'll hear from experts on the dangers posed by expanding surveillance apparatus, its impact on American citizens, and legislative solutions to safeguard our civil liberties. I thank the witnesses for their testimony. I remind each member that he or she will have 5 minutes to question the panel. And let me introduce our witnesses for the panel today. Thank you. Our panel of witnesses. Mr. Stephen Cash is the Executive Director of the State, a nonprofit organization comprised of over 400 former senior U.S. national security professionals. Mr. Cash most recently served as Senior Advisor to the Undersecretary for Intelligence and Analysis at the Department of Homeland Security, and previously served as Chief of Staff for the Office of Intelligence at the Department of Energy. Mr. Cash also served in several senior congressional staff roles, including as the first Minority Staff Director for then Select Committee on Homeland Security. Mr. Kia Hamadanchi is the Senior Policy Counsel in the National Political Advocacy Department of the American Civil Liberties Union, where he focuses on federal policy and civil liberties issues. Prior to his current role, he was a Senior Governmental Relations Associate with the P Street Project and Legislative Affairs Manager for the Congressional Progressive Caucus Center. He previously served in multiple staff roles in Congress, including as Oversight Counsel for the House Committee on Education and Labor. Mr. Patrick Eddington is a Senior Fellow at the Homeland Security and Civil Liberties at the Cato Institute, His work focuses on surveillance, intelligence policy reform, detainee interrogation, and the use of drones in both overseas and domestic contexts. Mr. Eddington is also an adjunct faculty professor at Georgetown University Center for Security Studies. Ms. Nicole Cleland is a private citizen, bravely coming forward to share how the government retaliated against her for conducting lawful observation of ICE and Border Patrol deployments during Trump's occupation of Minneapolis this past January. I now will ask our witnesses to summarize their statement for 5 minutes, beginning with Mr. Cash.
Ranking Member Thompson, members of the committee, thank you for giving me the opportunity to come before you today. I recognize the unusual nature of this proceeding, but particularly during periods of institutional stress and tension. In a situation we're in right now, congressional oversight and constitutional accountability must continue. As you mentioned, I'm the executive director of the Steady State. My colleagues are drawn from the national and homeland security communities, more than 400 of them, and they believe we're facing an existential threat right now. To be clear, for our professional lives, we were on the surveillor's side. It's what we did for a living. Spies, diplomats, military officers, and we are well aware of how dangerous our profession can be. We are also well aware of what happens overseas as an autocrat or a dictator rises. We see the pattern. We have spent our professional careers studying autocrats, studying dictators, sometimes even working alongside them and working alongside their security services. They are not trivial. They are dangerous, and we are well aware of that. As you mentioned, as the ranking member mentioned, my last job was with the Department of Homeland Security under the Undersecretary for Intelligence and Analysis. I helped run the intelligence enterprise. That's the people doing the surveillance we're talking about. Ms. Cleland, I offer you my apologies on behalf of my former office. I resigned on January 20th. I resigned because I saw what was coming, and what was coming was just what the ranking member described. Today, I hope to speak with you very briefly around two things that are happening now, and it's a conflation of two trends. And the first one is technological. The ranking member mentioned a whole bunch of technologies, from license plate surveillance to facial recognition, that are coming online. The world has changed since I started in 1994 as an intelligence officer, actually with the Central Intelligence Agency. It's more far-reaching, it's cheaper, it's ubiquitous. I try to count on my way in to testify today as I drove. I would estimate that I was picked up on at least 100 surveillance cameras who looked at my face, who looked at my driver's plates, who looked at my car, who knew where I was every moment of my trip from Bethesda down here. And they'll watch me on the way back. They'll watch the YouTube. They'll watch what I write about this, and they read what you wrote about it in your press release. All of that is critical. The other thing that has happened is it's reversed what was a trend right after 2001, when we created the Department of of Homeland Security. We were collecting a lot of data, but we couldn't do anything with it. It was too expensive. It was too difficult to management. We were recording, we were listening, we were watching, and we were filling reams of boxes with information that we could do nothing with. That day is over. Artificial intelligence and sophisticated analytic tools have dropped in price and allow the intelligence community and the Homeland Security to make something of all of that data, to do something with it. And that leads me to the second prong that I'm concerned about. It's already been mentioned. There's always been a tension between civil liberties and national and Homeland Security. But until now, that tension was played out in good faith negotiations within the executive branch, with negotiations between the executive branch and the Congress, including this committee, as well as oversight by our courts. That seems to have disappeared. The idea that the tension between those two things is something worth taking seriously and caring about deeply seems to have disappeared from American discourse. Those two trends, the ubiquity of the technology and the willingness to use it without oversight, without constraint, and focused on something new. As I mentioned, the department was created to look at external threats from terrorists. That's what we were worried about. We were afraid. But now the President has spoken quite clearly. He's issued NSPM 7. He's made multiple statements about what all of this capability and authority is to be used for. And it's to look at our domestic enemies. And when I say our domestic enemies, what I really mean is his domestic enemies. I hope the committee will be able to take on its responsibilities, and I applaud you doing this hearing today. Thank you for allowing me to testify.
Thank you so much. I thank you for your testimony. I now recognize Mr. Hamadanchi to summarize his statement for 5 minutes, and if I butchered it, I apologize.
You got it. Ranking Member Thompson and members of the committee, thank you for the opportunity to testify today on behalf of the ACLU regarding government surveillance programs that impact Americans of all backgrounds. Within DHS, ICE has built one of the most expansive and invasive surveillance operations in the federal government. While many of these tools are not new, and in some instances predate the current administration, the scale and integration of these surveillance technologies has expanded dramatically over the past year. ICE has deployed a smartphone application called Mobile Fortify that enables ICE agents to perform facial recognition searches against a data set reportedly containing over 200 million images. The app integrates multiple federal, state, and DHS databases, providing access to extensive personal identifiable information. The dangers are profound. Facial recognition systems have documented accuracy problems, and despite these issues, ICE officials have stated that a match by Mobile Fortify is a definitive determination of a person's status, and that an ICE officer may ignore evidence of American citizenship, including a birth certificate, when the app says a person is undocumented. ICE also plans to distribute a related facial recognition app to potentially more than 1,000 local law enforcement agencies participating in the 287G program. Congress must act before a flawed facial recognition system is placed in the hands of thousands of local police officers who are neither trained nor equipped to make immigration determinations. The U.S. Border Patrol has also secretively built a system of automated license plate readers that carry out dragnet surveillance of millions of Americans' movements. Border Patrol intelligence operatives monitor this data for movements they deem suspicious, though we know little about what they consider suspicious and what kind of algorithms they use. The network operates not just near the border, but far beyond it, capturing data that can reveal where people worship, seek medical care, attend political meetings, and engage in other constitutionally protected activities. ICE has also deployed cell site simulators, commonly known as stingrays, which mimic cell phone towers to force nearby phones to connect with them, allowing ICE to track individual locations. ICE has used these devices to locate and apprehend immigrants with the technology capable of sweeping up data from any phone in the vicinity, including those belonging to U.S. citizens who happen to be nearby. Additionally, ICE is deploying tools developed by Palantir that integrate data from multiple government sources. A tool reportedly called Elite populates maps with potential deportation targets, generates dossiers on each person, and provides confidence scores on current addresses. The system draws information from sources including the Department of Health and Human Services, U.S. Citizenship and Immigration Services, and commercial investigation databases. None of these technologies are likely to remain siloed within ICE. The infrastructure ICE builds will likely be shared with other law enforcement agencies, and the databases ICE accesses could become available to an expanding web of federal, state, and local authorities. We have also seen the growing practice of law enforcement and intelligence agencies circumventing constitutional protections by purchasing data they would otherwise need a warrant to obtain, including location records and data that can reveal a person's web browsing activities. Federal agencies that have purchased such data include the FBI, the DEA, ICE, the Secret Service, CBP, DHS, and the Department of Defense. According to former Deputy Director of the CIA, Michael Morrell, the information that is available commercially would kind of knock your socks off. If we collected it using traditional intelligence methods, it would be top secret sensitive, and you wouldn't put it in a database, you keep it in a safe. The Fourth Amendment is Not for Sale Act, which passed the House of Representatives with bipartisan support last Congress, would close this dangerous loophole. Finally, I would be remiss not to mention Section 702 of the Foreign Intelligence Surveillance Act, which is currently scheduled to expire on Friday, although surveillance under the law can continue under existing quarters until March 2027. Congress should be demanding answers to multiple questions before extending this authority for another day, much less multiple years. For instance, how are artificial intelligence systems being used in conjunction with Section 702? Have domestic agencies like ICE asked the FBI to run searches of Americans' communications? Has such authority been used in connection with the administration's efforts to target activists and nonprofits under the banner of domestic terrorism? The appointment of Bill Pulte as acting director of national intelligence only highlights the concerns with this program. He has no intelligence experience, and as director of the Federal Finance Agency has sent criminal referrals to the Justice Department targeting the president's political enemies. His appointment is a demonstration why Congress should not reauthorize this program without real safeguards, including a warrant requirement. This moment calls for a renewed commitment from Congress to reassert its authority to investigate and constrain the full scope of government surveillance. In 1975, the Senate established the Church Committee. It was one of the most significant efforts in American history to investigate and restrict the executive branch's infringement on civil liberties. It remains the gold standard of congressional oversight. A new Church Committee tasked with investigating the exercise and abuse of executive power and empowered to examine the full architecture of modern government surveillance would represent the first comprehensive review of presidential authority in nearly half a century. As Senator Frank Church himself warned, the capability at any time could be turned around on the American people, and no American would have any privacy less, such as the capability to monitor everything, telephone conversations, telegrams, it doesn't matter, there would be no place to hide. Thank you for your attention. I welcome your questions.
Thank you very much for your testimony. I now recognize Mr. Eddington to summarize his statement for 5 minutes.
Ranking Member Thompson, members of the committee, it's my sincere thanks for inviting me here today to share my views with you. I should note at the outset that my views are just that, not necessarily those of the Cato Institute or its board of directors. As a former intelligence analyst with the Central Intelligence Agency and a previously commissioned officer in the Army of the Republic, I understand well the threats that we face from abroad. In my view, none of those threats today are as grave as the threat that we face from our own government, specifically the executive branch and its sweeping law enforcement and intelligence gathering powers. As my colleagues have already indicated and the ranking member himself has said, the march of technology has made these powers all the more fearsome, particularly when they're combined with little or no meaningful judicial restraint on their use and an executive branch that will freely assert its inherent authority to use those capabilities at will. The Congress is once again debating one of those powers, Title VII of the Foreign Intelligence Surveillance Act, about which I opine on at length in my written statement for the record. But for now, I'll simply say this. The Fourth Amendment contains no so-called national security exception. Let me say that again. The Fourth Amendment contains no so-called national security exception, notwithstanding what the FISA court has done since 2015. That was a deliberate choice by the Constitution's drafters to have no national security exception in the Fourth Amendment. And it is one that mandates that a probable cause-based warrant requirement be added to the FISA Section 702 program. But making the 702 program truly Fourth Amendment compliant is critical. There's no question about that. But it's not enough to truly stop executive branch surveillance overreach. Indeed, it is the vast and ever-increasing amount of commercial digital data on each and every one of us and the ability of federal law enforcement to obtain that data with our own tax dollars that represents perhaps the greatest long-term threat to our civil liberties and personal privacy. And as my colleague from the ACLU noted, had the Senate act on the House-passed Fourth Amendment is Not for Sale Act in 2024, it's likely that this legislation would be law and the commercial information currently being used at will to target President Trump's political opponents would require a warrant to obtain today. Enactment of that legislation or its equivalent is of paramount importance to close the so-called data broker loophole that affects all of us. However, any governmental reform effort must also contend with the fact that reining in the surveillance threat that I and my colleagues are highlighting only addresses the problem related to the tools themselves, not the mindset and the power wielding them. Twice in my lifetime, I've witnessed two presidents misuse the Department of Justice to achieve their own political ends, Richard Nixon and Donald Trump. In each case, such presidential misconduct has triggered a constitutional crisis and wide-scale civil unrest. So long as the Justice Department remains within the executive branch, a political branch of government, It will always be a powerful, coercive tool waiting to be used by another unscrupulous president. To avoid that outcome, we have to change the very structure of our government. In my view, that process must begin with moving the Department of Justice out of the executive branch and placing it under the administrative control, not the operational control, but the administrative control of the federal judiciary. Under my proposal, no federal judge, including the Chief Justice of the Supreme Court, would have line of control authority over a DOJ relocated to the federal judiciary. However, this change, taking an ostensibly neutral but frequently politicized law enforcement entity out of a political branch of government and beyond any president's control, is likely the only certain way to preclude a future domestic tyranny. Indeed, it was the chairman of the Senate Watergate Committee himself, the late Senator Sam Ervin of North Carolina, who became convinced as a result of Richard Nixon's misuse of the Justice Department that it should be moved outside of presidential reach. Unfortunately, his proposal never became law, and we have been paying the price for that failure ever since. A new Congress can and must take up that fight again if we want our republic to last another 250 years. Thank you again for your kind invitation, and I stand ready to answer your questions.
Thank you for your testimony. I now recognize Ms. Clellan to summarize her statement.
Ranking Member Thompson and members of the committee, thank you for the opportunity to testify today. Like many Americans, I cared deeply about my community and wanted to better understand what was taking place during federal immigration enforcement operations occurring in my area. I'm here today because I have questions that remain unanswered, and I believe those questions deserve continued oversight by Congress. In late 2025 and early 2026, I participated in community efforts to observe federal immigration enforcement activity in public spaces. I completed legal observer training and understood that I had the right to observe public officials carrying out their duties in the public, so long as I did not interfere with their work. On January 10, 2026, during Operation Metro Surge, a months-long immigration enforcement operation launched in Minnesota by the Department of Homeland Security, while observing federal officers from a distance, I was stopped by a Customs and Border Protection officer. The officer addressed me by name and told me that facial recognition technology had identified me. I was also warned that if I continued following officers, I could be arrested. After the encounter, I sat in my car, replayed what had just happened. It didn't feel real. It also didn't align with my understanding of the rights I had been taught during legal observer training. I called my husband to let him know I was okay, talked him through what happened, and went on my way. I then went to the next location where observers expected federal officers to be present. As I waited, I found myself thinking about the officer's warning and whether I could actually be arrested for continuing observing. For the first time, I felt genuinely concerned about the possibility, and I was shaken. Ultimately, I decided to go home rather than continuing to observe. 3 days later, I received notice that my global entry membership had been revoked. I had been a member for more than a decade. The notice provided no meaningful explanation beyond stating that I no longer met program eligibility requirements. Since then, I have tried to understand not only what happened, but also how it might impact me going forward. I found myself asking questions I had never considered before. Was my passport still valid? Would I encounter problems while traveling? Had I been placed on some type of watch list? My husband and I even took a short trip to see whether I would encounter any issues. Fortunately, I did not. My passport worked fine, and I experienced no travel issues. But the questions didn't disappear. Even now when I travel, I wonder whether I will encounter an issue. More broadly, I've wondered what information is being collected. What is being monitored? How is that information being used? Those are questions I never thought I would be asking as a citizen engaged in what I believed was lawful, protected activity. I submitted a FOIA request in January seeking information about the decision and any records related to it. I was told that because of agency backlogs, it could take 9 to 12 months for me to receive a response. To date, I still do not know what information was collected about me, how it was collected, how it was shared, who had access to it, whether or not it played any role in the decision to revoke my membership. I want to be clear. My purpose here today is not about losing the privilege of global entry. It is about the how and the why behind it. It is about the implication for Americans everywhere who may be in danger of this happening to them as well. It is about preventing chilling tactics from becoming a norm. If I can be punished for speaking out, anyone could be at risk. I cannot speak to the motivations of the officials involved. What I can say is that after engaging in lawful activity protected by the First Amendment, I was identified by name through surveillance technology, warned against continuing that activity, and then subjected to a government decision that affected me. Months later, I still don't have any answers. That lack of transparency is what concerns me. As an American citizen, it is my understanding that I have certain unalienable rights. To learn that I've been watched, scrutinized, and possibly punished for participating in those rights has been a surprising and unsettling experience. The experience has also changed my own behavior. Where I was once enthusiastic to engage and help my community in its time of need, I am now more hesitant to participate in the kinds of lawful community observation activities that I previously engaged in. I don't know what the consequences might be. Whether that concern is warranted or not, it is real, and it has had a genuine impact on my life. One reason I agreed to testify is that I know there are others who are not willing to do so. Whether their concerns are justified or not, they are concerned enough about potential consequences that they do not want their names associated with these issues publicly. That reluctance to speak openly is itself a reason for why continued oversight is essential. Friends and community members are afraid of what will happen to them and their loved ones for simply exercising their legal right to observe what was happening in their own neighborhoods. My concern extends beyond my own experience. Americans should not have to wonder what information the government is collecting about them, how that information is being used, or whether it could affect them for engaging in lawful civic activity protected by the Constitution. I am a testament to the effect that these surveillance tactics can have. When the government uses its tools to track citizens observing public officials, it sends a clear message. Speak up, and you will be targeted. This creates a chilling effect that erodes the fabric of our democracy. I'm not asking this committee to reach conclusions about my case. I'm asking you to continue asking questions. How is information being collected? How is it being shared? What safeguards exist to prevent misuse? What protections exist for Americans engaged in lawful First Amendment activity? And when government decisions are made, what level of transparency and accountability should the public expect? Those are the questions that brought me here today. Those are the questions that need to be clearly answered and defined for the American people in order to preserve our democracy. Without those answers, we are left to wonder what type of surveillance actions and retaliation are being carried out by our government. That creates confusion, and confusion is dangerous. That confusion can be weaponized to do more harm. Please seek these answers so that our institutional guardrails remain strong and protective. Thank you for your time, and I look forward to your questions.
Well, first of all, let me thank all the witnesses, but Ms. Cleland, let me thank you for your courage to come and testify before this committee based on your own personal experience. And so much of your questions for the committee is why we exactly having this hearing, because we really want to get to the facts on this oversight and come with some recommendations. And I assure you, we don't have any freaking violence on the committee, that we'll come forward with whatever that recommendation is. But taking off from your questions, I want to ask our three other witnesses, would adding guideposts to our surveillance policy make us less safe or more safe as a country? Mr. Cash, we'll start with you. Please.
Certainly wouldn't make us less safe. Adding clear guidelines to what already exists would help. Unfortunately, I think I would have to say it wouldn't make us much more safe, at least not while the executive branch exhibits such contempt for the guidelines and guideposts and guardrails that already exist. So I'm a little bit bleak on that. Where I see light is if those additional guidelines are coupled with active and embraced, and that's probably too much to ask, oversight from this committee and other committees.
I would say in many areas, Congress is very easily able to strike the balance between security and liberty, and I think that by providing guardrails and safeguards, it's very, it in fact makes us more safe because you're protected from an executive branch that's abusing its powers. But I'd also say the Fourth Amendment exists for a reason, and every situation where we have warrantless access to Americans' communications, we should make sure that you should get a warrant before you can access those communications.
Mr. Thompson, I think it's important for everybody in the room to be reminded of the fact that 9/11 did not happen because my former employer, the Central Intelligence Agency, and the National Security Agency, and the FBI did not have enough data on the enemy. They had the data. But in the words of the chair of the 9/11 Commission, former Governor Tom Kean, they failed to connect the dots. That's how it works with every intelligence failure that I'm familiar with over the course of the last century. So my perspective is very much, I think, aligned with my colleague from the ACLU. As I noted in my opening statement, and I go into this a lot more in my written, the founders were among the most brilliant, if flawed, but still brilliant men who've ever lived. They wrote the Fourth Amendment, having themselves used before, during, and after the Revolution what we today call encryption. Back in the day, it was called codes and ciphers. So they understood what they were doing. They wanted to protect their communications first from the British Crown and then basically any unfriendly prying eyes. Every American should have the right to that same kind of protection, and that was their vision. So if they had wanted a so-called national security exception in the Fourth Amendment, they would have put it there. There's no question about it. As a former intelligence officer, I will tell you that the biggest problem that happens most of the time is that people do not analyze the data they have, collate it, and get it out to people who need to have it. That's the number one problem that we see. And finally, just very briefly, we're hearing members tragically on both sides of the aisle, not just in this body, but in the other body, continue to make the false claim that if FISA Section 702 lapses, even for a brief period, we go dark. As my colleague from the ACLU pointed out, there are multiple additional authorities, including FISA Title I, Title III, and others, that the government will easily be able to rely on, in addition to Executive Order 12333 and other authorities that I have no doubt exist that are not currently public. So no one should go into this debate over FISA thinking that suddenly we're going to be wide open to attack. They're able to keep this data that they collect under the 702 program for at least 5 years. We know that. So on any current target, they're going to be able to continue to go after that per the actual certifications that exist right now. But we need to get back to a place where we actually have a truly liberty-centric society, and we are light years away from that right now.
Well, thank you. My other question is, Ms. Cleland really was a law-abiding citizen, doing what she perceived the law allowed her to do. So what do we say to our constituents who are concerned about surveillance, who say, well, the supporters of surveillance say, well, if you haven't done anything wrong, why are you concerned about surveillance? You kind of get what I'm saying? Is it a necessary evil so that in the process of looking for bad people, you catch good people? And if you haven't done anything wrong and you're good, why complain? Mr. Cash?
Well, the central part of that question is if I've done nothing wrong. One of the fundamental problems is that under this administration, the definition of wrong has expanded. If I read NSPM 7, if I listen to what the President has said, I've done something wrong. You've done something wrong. The members of this committee have done something wrong. You're members of a party that has been described as treasonous. So if the person or people deciding if you've done something wrong and therefore you should be subject to surveillance or making that decision, I don't think it saves you to say I'm a good person. The choice between good people and bad people is not how we do intelligence work and not how we do Homeland Security work. And we can't do it that way. It will not work in a way that's consistent with the Constitution or American values.
I would say anyone who says if you haven't done anything wrong, you shouldn't worry about surveillance. Well, we should surveil those people and take that and put it public, and for everyone to see and see how they feel about their intimate details being revealed for the entire public. And the thing is, as Americans, we have a right to privacy, and maybe you haven't done anything wrong, but there are intimate details about your life, about what you've been doing, who you've been talking to, that maybe you don't want other people to know, and that's our right under the Constitution and under the Fourth Amendment to be protected from unreasonable search and seizure. And I think one of the things you see from the surveillors always is it's never enough. There's always this constant threat. Well, if you don't give us this data, everyone's going to die. And it's this constant fear-mongering that has never, ever been backed up by the reality.
I think it's also important to remind the members and anyone else who might be listening to this or watching this that it was literally just hours after the 9/11 attacks that then General Michael Hayden, the director of the National Security Agency, violated federal law, specifically the Foreign Intelligence Surveillance Act, by telling his people to start collecting any and all traffic flowing between the United States and Afghanistan. You can't trust people in the executive branch with this kind of power and this kind of authority in any kind of unregulated way. That's the lesson of history. Last year, Georgetown University Press, and thank you for the mention of my fellow Hoyas, Mr. Thompson. Georgetown University Press published my book, The Triumph of Fear, which basically looks at this very phenomenon that we're discussing from Theodore Roosevelt's day right up through President Eisenhower's last day in office. And my view is that we are reliving a new kind of Cold War Red Scare moment. That's what's happening here. But what this particular Trump 2.0 version has done is it's turned it so broadly against so many sectors of society, it seems to have almost no limits. So they go after the lawyers, they go after the universities, they go after the immigrants, legal or otherwise, legal or otherwise. They go after individuals. And then they go after people like our Minnesota Strong person here. And her testimony is an example of the concrete harms that we see from these policies, this chilling effect. It's real. And as I've written elsewhere, this is actually a phenomenon that researchers have tracked. You can actually measure this chilling effect and what it does to corrode society. So to me, unless we get back to a place where we have an executive branch that is under control, and you already heard me talk about my proposal to begin dismantling some of that and moving it to a place that cannot be ultimately politicized in any kind of meaningful way. I think that's exactly what has to happen. These powers were never really meant to be lodged in the executive branch. You can make an argument that sometimes in wartime you have to maybe bend the rules a little bit. Even I don't believe that. Because the minute you allow that kind of corrosion to take place, it begins to completely destroy the very fabric of the republic.
Thank you. So, Ms. Clellan, what would your encouragement to this committee be, given your experience with our government and its tactics for surveillance?
Thank you for the question. From my perspective, my ask is having there be clarity around why, having there be a clear understanding of who and what is the information, what is the purpose of it. Right now, with what I experienced, I don't understand any of those questions. I have no answers for any of that other than it feels like retaliation. So needing to understand, again, the reason behind it and that it actually makes sense.
Thank you so much. And I thank the witnesses for their response to the questions. We will now hear from the gentlelady from Chicago, Ms. Ramirez.
Thank you, Chairman. I think he's my chairman, ranking member chairman, same thing for me, for convening this hearing, and I want to thank you all for being here today. Since day one, we've seen this administration's attack on federal services. We've seen them push this authoritarian agenda and blatantly, as some of you have mentioned, broken the law. Agents in masks, arrests without valid warrants, tampering with license plates during operations, and violations of due process are all tactics that undermine the rule of law and certainly make us all feel less safe. In addition to the clear violations of the law, the administration expanding the state's mass surveillance apparatus, weaponizing biometrics, AI data, and more against our country's residents. From ankle monitors and data sharing to facial recognition and biometric tracking, DHS is unchecked, unaccountable surveillance capacities are being turned on us to suppress dissent and to intimidate everyday people from exercising their basic rights as a U.S. citizen. During DHS's Midway Blitz, I regularly heard drones and helicopters over my phone. I'm talking about being in a meeting with caucus and hearing another Black Hawk helicopter over my home. We heard neighbors alike say that they were using biometric and surveillance systems in our streets. Well, next month, I look forward to continuing today's conversation at a shadow hearing on technology behind ICE and how DHS is using those technologies to advance authoritarianism. See, the administration's systematic effort to expand the use of surveillance erodes privacy rights, it intimidates critics, and it centralizes power. And we know that's undeniable, and it's why today's conversation and having the four of you here is so important. So, Mr. Hamadanchi, did I say it correctly? Yes. I want to ask you a question about something my constituents in Chicago have been raising to me directly. They keep talking about license plate readers. As you know, these are the cameras mounted on police cars, road signs, and bridges that photograph every passing license plate to create a detailed record of where people have been. In Illinois, we already know this data has been accessed illegally, including by a Texas sheriff looking for a woman who had an abortion. Our Secretary of State found that hundreds of other searches violated state law. If a state law meant to protect Illinois residents can be circumvented that easily, in your opinion, what protections do my constituents actually have? And I'll ask you the follow-up, if you can answer. What does Congress need to do at the federal level to ensure adequate protections?
Yeah, what I've said is we've seen with a lot of license plate reader state regimes, not just in Illinois and other states, that consistently these laws have been violated. And I think that that's why Congress should act and when it comes to automatic license plate readers. Because clearly we see data sharing across states violating these laws, where people are sharing things like the example you said in Texas, and that's why we need a national regime. And also we've seen Border Patrol abuse these technologies, and part of it's in places that are nowhere near the border, which is part of their whole idea that the border is everywhere. And Border Patrol is using these and essentially become an intelligence agency, and that's the sort of thing that Congress should put a stop to.
Ms. Cleland, you said you've stopped doing rapid response legal observer work after the administration revoked your global entry because you didn't know how far they'd go. Certainly, even after that experience you had that first day. That's not a small thing. It's actually a chilling effect on a First Amendment right in real time. So I want to ask you, I've heard you talk about the impact it's had on you, the impact it's had on other people who want to be rapid responders, who know that even in a change of secretary, there are still abductions happening. What do you feel, in your opinion, needs to happen for you to feel safe enough to exercise your basic rights again?
Thanks for the question. A clear understanding of what those rights actually are. And, I went through training. I felt really, really confident that I was following to the best of my ability what was being asked of me, and that I would be safe. And that's just not the case. And so there has to be some level of trust that's rebuilt, that right is right and wrong is wrong, and that you have the ability to go do what you want to do under your First Amendment right and not have that be taken against you.
So it means that those rights be protected,
Absolutely.
be defended. And when you've gone through training to know your rights and you experience a situation where your rights are being violated, there's consequences, right, to those that are violating your rights. Folks, what's happening to our constituents around the country is bone-chilling. That's why this hearing is so important. I want to thank our ranking member and all of us here for bringing this issue to the broad daylight because it is impacting all of us. And to your point, history will repeat itself if we don't actually change course, and Congress has a responsibility to change course. Thank you. With that, I yield back.
Gentlelady yields back. Chair recognizes gentleman from California, Mr. Correa.
Thank you, Mr. Chairman. I want to thank our witnesses for being here today, for having strength and bravery to be here testifying. Our president got elected promising to deport the worst of the worst. 70% of all people being deported are honest, hardworking taxpayers. We can talk about undocumented, but I think it's more basic than that. It's about American citizens. I would argue it's about American citizens. We talked FISA 702. Homeland Security, $170 billion. Another $70 billion on top of that. That buys you a lot of equipment, a lot of goods. If you're going to deport the worst of the worst, this is overkill. This is a lot of money, and it's not designed just for deportations. This is designed for something bigger than just deportations. And as you've all have said, we're talking about border security being implemented far away from the border now. I'm going to ask all of you, each and every one of you, does, in your opinion, the government have a database on American citizens? Mr. Cash.
No, worse than that. But
So the answer is yes, but worse than that.
Well, it's no. It has many databases which all can speak to each other. And
By what constitutional authority, by what legislative authority?
I don't think there is either specific legislative authority, and there's certainly not explicit constitutional authority.
So we in this country that have valued our freedom, our privacy, unlike any other country in the world, no longer have that.
I think we are getting exactly to that place. Not every other country, but I would particularly look at the countries that are ruled, I use that word deliberately, by autocrats and dictators. The kind of assemblage of information and the access to that information that we're seeing happen here is what every single autocrat that we've looked at in my career does overseas. It's the first step.
Mr. Hadamachi.
Yes.
Yes, what?
I'm just saying yes to you calling my name.
The database.
Does the government have a database on American citizens?
As Mr. Cash said, it has multiple databases. I think the question you're asking, does it have a database of domestic terrorists, which some of the ICE agents have been saying to people who have been protesting? And the question is we need to find out, because administration officials have given multiple inconclusive answers when asked about that. And Donald Trump is clearly wants to pursue his political enemies under the guise of domestic terrorism, and there are no domestic terrorism.
So when Alex Petty was shot, immediately, recall, fact check me here, Homeland Security Secretary came out and said he was a terrorist focused on harming federal agents. So before this individual, before anybody knew anything about him, the justification was he was a domestic terrorist. He was an American citizen, and I want to say he's not of color, okay? He's not a brown person. He was shot dead. He was called a domestic terrorist. So I'm trying to figure out here, what are we talking about here? Anybody then whose name is on one of those databases is now there because he or she's a terrorist?
I think that you've seen the administration call a lot of their political enemies domestic terrorists, but there is no statutory basis for that.
Mr. Eddington.
The direct answer to your question, Mr. Correa, is yes. It's called the Real ID Act.
Explain.
Real ID is something now that you have to have if you want to get on an airplane and go anywhere in this country. Your state issues it to you, but it's a federal mandate. And there is no constitutional basis for the control of individual human beings traveling from one state to another. There is no basis for it. So that's an example. My colleagues up here have given you some other examples of all these databases that are out there. But you've put your finger on an important question, which is there a supermaster database that they have been building of people? And if you look at what this Doge thing did right? What was it really all about? It wasn't actually about cutting government waste. It was about gathering data. Data on you, me, everybody. For what purpose? For what purpose? Asking states to turn over their voter rolls for what purpose? That the Trump regime can decide who gets to vote and who doesn't get to vote? Kind of feels that way to me. So yes, multiple databases, but my ultimate question is this being congealed essentially into some kind of master database that only the highest level officials in this particular government have access to?
And again, by what constitutional authority, by what legislative authority?
None.
So this would be an unlawful gathering of data of American citizens who are essentially not guilty of any crime.
In my considered judgment, the answer is yes.
Ms. Cleland, you're looking for transparency. What happened? I think all of us are. And I think we kind of instinctively know the answer. We know the answer. Why would you, as an American citizen who's done nothing wrong, all of a sudden your data be available almost at an instant to a federal agent out in the street? You know, let me take you back a little bit. Kristi Noem was fired. Pam Bondi was fired. I thought they were doing everything that they were supposed to do. Why were they fired? This is concerning. Ms. Cleland, you're concerned because your information is somewhere in a database. I think every American should be concerned as well. You start with the real ID. And we all, I think, kind of accepted that for reasons of national security. But now you're looking at the real ID information coordinated with other databases being accessed by authorities and maybe foreigners that we have no control over, that we have not given our legal authority to look into. Mr. Cash, am I talking here nonsense, or are we looking at something that is happening?
You're not talking nonsense. The only quarrel I'd have with what you said is the use of the word concern. I don't think it's strong enough. The word I use from how I feel about it is terrified, which in common.
So you're terrified by what the federal government is doing with our privacy, our data, and our liberty and our constitutional rights.
Absolutely.
Ms. Adamachi.
Yes.
Mr. Eddington.
One of the things that I've learned, Mr. Correa, is it doesn't matter whether you talk about the Trump regime or the Biden regime or any previous regime. I tend to use that term a lot. I'm not a fan of the executive branch. This process has been going on a long time. A lot of previous presidents, previous Congresses, both parties are responded. My colleague Kia has used the phrase scaffolding to describe how we got here. What Mr. Trump and the people that surround him are doing is they're maximizing these powers, these authorities, and these prior judicial decisions that have handed the presidency these massive powers. And they're using them on steroids, but they're using them almost exclusively to go after their alleged or perceived political enemies. So that's got us on a path to a de facto tyranny. I mean, I look at the presidency not as a nominal chief executive anymore. It really is much more like a monarchical position, given the power that's been accumulated or handed over to the presidency. That's not what the founders had in mind.
I was just told that my time has expired. Ms. Cleland, any thoughts?
I have a lot of thoughts. I believe there's a list. I believe there's a lot of lists, and I'm pretty sure I'm on more than one.
I want to thank all of you for your strength and bravery for being here and testifying. Mr. Cash, I'm with you. This has to terrify us. Thank you.
Thank you very much. We now recognize Mr. Magazina for his questions.
Thank you very much to our once and future chairman and to my colleagues and to all of you for taking the time to be here today. The very first thing that Donald Trump did when he took office in this administration was to allow Elon Musk and a group of young, inexperienced, unvetted 20-somethings access to every American's personal data in the Social Security database, in the HHS, Health and Human Services databases, and others. People's bank account information, Social Security numbers, health care information. Young people who had no security clearance, who had no background in how to manage or handle sensitive information were given full access to these databases with the personal information of every American. And we still don't know this. We'll find out when Democrats get the gavels back and have subpoena power, but there are rumors that as part of that process, Elon Musk had a server in his office that they were routing data from these databases through. We still have no idea if that data was inappropriately shared with Mr. Musk or his companies or anyone else. Then the president began appointing people to key national security roles with no qualifications whatsoever except for the fact that they are willing to do absolutely anything the president tells them to do. Kash Patel at FBI had no law enforcement background, never had a badge, never conducted arrests, but was appointed to lead the FBI, the largest and most important, largest at the time and most important federal law enforcement agency, only because he was willing to act upon Donald Trump's conspiracy theories. Now, the president has appointed Bill Pulte to the highest intelligence role in the federal government, somebody who has no background in intelligence, no background in the armed forces, whose only experience in government at all is a short tenure at the Federal Housing Authority, where he used that position to attack and investigate the president's political opponents. Now, once again, with no security clearance, being appointed to the top intelligence role in the Trump administration. It is clear that the Trump administration is intent on using the levers of government, including the personal data of Americans, to go after the president's political opponents and to act upon his grudges in violation of the constitutional right to privacy that every American is entitled to. So listen, I've generally been a supporter of FISA 702. I believe that it can be, with the right guardrails, an important tool to prevent terror attacks in the United States. But we cannot ignore the context of what is happening here and the fact that the administration, the Trump administration, is putting people into positions of authority who have no technical background or expertise or training, who had no clearances, but are being chosen only because they will do Donald Trump's bidding. And that should send a chill down the spine of every American. So as long as Bill Pulte, Kash Patel, people like that are running the show, we can't continue to authorize this authority. With the time I have left, Ms. Cleland, I just want to make sure for the record that this is clear. So when you began observing the federal ICE and Border Patrol actions in Minnesota, did you at any time impede the ability of federal agents to do whatever it was that they were doing?
At no time did I impede.
Did you ever stand in their way or physically assault them or try to stop them from doing what they were doing?
At no time did I do any of that, no.
Did you stand too close to them to a point where they could have felt threatened?
They had to walk towards me.
Okay. And when they walked towards you on January 10th, they told you what exactly?
Again, addressed me by name, said, "Hi, Nicole, you are impeding our ability to do our job, and if you continue to do so, we can arrest you."
Do you know how they knew your name?
I have no idea.
Okay. And they said to you that it was from facial recognition technology. Is that right?
Correct.
So they used facial recognition technology to identify you, an American citizen exercising your constitutional rights who had not impeded them in any way. And then, in the days that followed, your global entry was canceled?
Correct.
And so, what do you think would have had to have happened there? I mean, multiple people would have had to have been involved in order to make that chain of events happen. Is that right?
It seems to me there would have been.
Yeah. Well, again, I'm sorry that you had this experience, but I fear, given the Trump administration's complete lack of regard for the civil liberties of the American people, for the laws of our country, and for the Constitution that we all swore an oath to uphold, that unfortunately your experience is about to become very common unless Congress does the right thing to step in and act. And thank you all.
Gentleman's time has expired. Chair recognizes the gentleman from Michigan for 5 minutes, Mr. Thanadar.
Thank you, Ranking Member Thompson, for having this important shadow hearing today, and for all of our panels of witnesses who can speak to the abuses of power committed by the Trump administration. For over a year and a half, the American people have stood up to the repressive Trump regime, which has targeted our communities with militarized immigration raids, challenged our rule of law, and blatantly attacked Americans for simply exercising their constitutional rights, including the First Amendment right to free speech. We have heard repeatedly of a so-called database of Americans used by agencies like ICE to spy on Americans, exercising their right to protest the unlawful actions of this administration, even demanding the records of Americans who have profiles on Reddit, TikTok, Instagram, and other social media platforms. We speak often about the dangers China poses to its own people regarding its massive surveillance, both physical and digital. Are we really going to turn a blind eye to when it happens here at home? Mr. Cash, how can we protect individuals who are exercising their First Amendment rights, protesting, filming, observing ICE operations from government surveillance and retaliation?
First answer is you're doing it with one hand tied behind your back today. Oversight. Shadow hearings is what you can do now. It's what you need to do now. If and when there is a Congress willing to do complete and real oversight, that's the second thing. And the third thing, in addition, perhaps, to strengthening the guardrails we've talked about, we cannot forget the ultimate power that this body has in addition to legislation, which is the power of the purse.
Thank you. Mr. Hamadanji, how can individuals or organizations determine whether they are being surveilled or punished for protected speech, and what resources are available to them?
Yeah, I mean, I think the unfortunate thing with surveillance, it's often the case that you don't know that you're being surveilled. We have a general idea in terms of government surveillance programs, but we often don't know. An actual individual doesn't often know that they're being surveilled, and that's part of why it's so problematic, because I don't know, I have no idea what information the government is gathering on me and what information, what purposes they're using it for. And it's often the case the government itself doesn't have a full understanding of what that information is. There was a report on data purchasing by government agencies, which Odie and I said, the government has no government-wide understanding of what agencies are buying what data and what purpose. And I think the answer is more oversight from Congress.
Thank you. And finally, and I have just a little bit of time left, I've heard many concerns from my constituents about how President Trump intends to interfere with our elections this coming November. Recently, the Trump DOJ demanded the voting records of my district from the 2024 federal election. This has put my community on edge, and I am doing everything in my power in collaboration with my district and the state of Michigan to push back against this illegal action. Mr. Eddington, how can states protect their election systems and infrastructure against possible federal interference or surveillance during the 2026 federal elections and beyond?
Well, sir, if the federal government were to engage in any kind of surveillance of election workers, things of that nature, that itself would be a violation of federal law. Unfortunately, it would be that same Justice Department that would have to prosecute any kind of violations. Hence my suggestion you take the Department of Justice out of the executive branch. And look, I know it's a heavy lift, right? It would take a constitutional amendment to do that. I understand it. Senator Ervin understood that too. But I think we've had Nixon, now we have Trump. There could be somebody else who comes down the line, God forbid, who goes even further, right? And that's why we have to have fundamental structural reform in that area if we're going to have a chance of preventing it.
Thank you so much. My time is up, and Chairman, I yield back.
Thank you so much. Chair now recognize the gentlelady from New Jersey for 5 minutes.
Thank you, Ranking Member Thompson, and thank you all for your testimony today. I'll share that up to actually 7 weeks ago, I was on the other side of this table. I was the co-director for the Center for Popular Democracy, which is a network of grassroots organizations that essentially focus on how do we uphold our democracy and our republic. And so I fully agree with you that this is a slippery slope towards authoritarianism, and we're like midway down this mountain, if not damn near at the bottom. Excuse my language. I'm from New Jersey. This is how we talk. I would like to, a lot of the questions that I had have been asked by my colleagues. What is remaining for me is DHS has acknowledged that they are collecting what they call biographic and biometric information. And they've also somewhat admitted that they're collecting DNA samples, but they haven't been clear about how they're storing that information. Am I correct in that? That's question one. That they've been opaque at best on what they're doing, how they're storing it, if they're storing it. My second question, so one, I wanted to know if that's your understanding as well. Two, what steps can we as members of Congress take in order to secure that data if they are in fact collecting it? What steps could we take right now? And what recourse do individuals have in terms of protecting themselves in that data? Are there legal recourses? Are there class action lawsuits that are possible? What is available to both individuals and this body? I know that's a lot. All of you. We could start with Mr. Cash.
Opacity. I don't expect it. Anything that you're being told is either accurate or truthful. So, no, there is no opacity. I do not know whether they are competently storing either the digital information or perhaps even the digitized DNA information. I'm not sure from the perspective of the executive branch it matters. Usually when we're talking about forensic storage of evidence in a law enforcement context, it'll be tested by a court. That's not going to happen here, and I simply don't see any evidence they care very much. As to your question of what recourse do ordinary people have, I hate to say it right now, almost none. We don't know what's being done, and there's almost no way to test it. Having said that, there are two areas. One, again, we're seeing it today. It's all of you, members of Congress. And second, it's elections. voting. That's where the power lies, and that's what's left to us. There is a role for courts, but it is unlikely that the kind of surreptitious surveillance you're talking about, and my colleague, Mr. Hamadanchi, is exactly right. Surveillance done well is not detected. I come from a world of professional people who do that. We're not supposed to let people know we're doing it. I can't speak to the competency of the people in DHS now, but when I was there, they were very competent. So I don't see a recourse.
I would say in terms of the retention, that's a major concern in terms of like how much they're retaining the data. I mean, the Mobile Fortify is a good example of they're taking photos of American citizens and they're retaining that data for we don't know how long, because that's a program that was never never authorized by Congress. And I think that is absolutely the sort of thing that Congress should be asking more questions across the range of biometric programs in terms of what data you're gathering, what purposes it's being used for, and how long you're retaining that data. Because I suspect in almost every case they were retaining it for far too long. I mean, they probably shouldn't be gathering in the first place, but they're retaining it. And the second thing is, and I would say Congress should try to restrict these programs, and that may not be possible in the short term. But I mean, programs like Mobile Fortify need to end. In terms of the question on what a legal action is, I mean, there are various lawsuits going on right now, and we'll have to see how those play out. I mean, I think the hardest thing is always, it's very difficult to show standing that you have been affected by this program. There's been a lot of, Section 702 is something that the ACLU first sued on under Section in 2008. Now we're after it was first passed in the law, and unfortunately we've run into issues of standing because it is very difficult to show that you've actually been surveilled by the government in these programs, so that you've been harmed. Even though we know it's very likely that certain people that's happened, it's very difficult to show in a court.
While I'm out of time, Ranking Member, if I
Give a little more.
Thank you. I don't know if Mr. Eddington or Ms. Cleland want to add.
I have some advice for you. It's my understanding that the majority may have changed the rules such that you can no longer employ resolutions of inquiry in quite the way you could when I was in the House. But if I were you, I would look into that. Perhaps there are some privilege resolution variants that could be used here. But going to GAO and asking them to conduct an investigation to find out where this is going on, if the ranking member were willing to, co-sponsor such a letter to GAO, and could find some other members, either ranking members or ideally people in the majority, chairman who'd be willing to sign on for something like that, that would at least get the ball rolling on your data-related question. But there's no doubt in my mind that you need a statutory requirement to prevent this kind of thing.
Just for the record, we have no hesitation on asking for any kind of information. So if the witness will help us in drafting such a request, we'll gladly do it.
It would be my pleasure. Thank you.
Cleland,
I don't have anything else to add.
Okay. Thank you for your answers. Chair now recognizes the gentleman from Texas, Mr. Green.
Thank you, Mr. Chairman. And I'm greatly appreciative that you allowed us to have this opportunity to have these outstanding witnesses appear and to receive intelligence from them. I'm also grateful for your opening statement, and would associate myself with it, and would have the record reflect that I associate myself with the statements of the chair. George Orwell, in his dystopian society, 1984, calls to our attention some things that I think are very much taking place today. But there's a statement in 1984 that seems to stand out in my mind. And that statement is, war is peace. We have a secretary who believes that we negotiate with bombs. He said as much. We negotiate with bombs. War is peace. Change the Department of Defense to the Department of War in an effort to acquire peace using the military in places that we did not anticipate and in ways that we did not anticipate. But that phrase that I called to your attention also has another statement associated with it, and it is, freedom is slavery. Freedom is slavery. You don't have to have chattels on you to be a slave. You can enslave people by knowing their every move, by causing them to be very conscious of everything that they do for fear that associating with someone that may be engaged in some activity that you're not aware of, but that activity may be harmful to your reputation. So you start to disassociate and isolate. But the phraseology goes on to say, and this is the one that really concerns me the most, Mr. Chairman, ignorance is strength. Ignorance is strength. We are seeing a level of ignorance being perpetrated and perpetuated from the highest office in the land that is unthinkable. It's just unbelievable that the president can say some of the things that he says, and there are people who literally take that as the gospel. For example, he's still saying he won an election that scores of courts have said he didn't win. But he says, I won. And he's still investigating it. Ignorance is strength. Now, having said all of this, I really am concerned about smart glasses. I really am. I don't know when I'm being surveilled if you have smart glasses on. I'm not sure about how that information is being stored, who has access to it. I don't know whether it can be hacked by some person whose nefarious intentionality can be of harm to me. I'm really concerned about smart glasses. I don't know that we should go so far as to say that you can never have them, but I would like to know that if you wear them in the public, I'd like to know whether you need a warrant to just invade upon my privacy with these smart glasses. So maybe I'll start with the ACLU. You have a yearning desire to make sure that we have our privacy and our liberty. What are your thoughts about smart glasses being used to surveil people with intentionality in the public?
Look, it's absolutely concerning, and I think it speaks to technology right now is advancing at such a state that it's blowing through every sort of oversight structure that we have. And I think it's really important that Congress does its best to keep up with this things like smart glasses, and that's not the only thing, but like the surveillance state is being supercharged by things like smart glasses, AI, and once you let these things out of the box, it's almost impossible to put it back. And so you have to restrict it as soon as you can, because once it's out there, then it becomes a thing where it's like, no, we couldn't touch this. People are gonna die or something like that.
Would anyone else care to comment? Mr. Chairman, I'm about out of time. Yes.
Appropriations language, no funds shall be expended under this act for the purchase of so-called smart glasses, et cetera, by any department or agency of the federal government. That's what I would do right now. That's how you get to a place, at least temporarily, where you can begin to kind of manage the problem. But I see no reason for DHS, ICE, any other federal agents to have that kind of technology just walking around. That's just continuous mass visual audio surveillance. That's unacceptable as far as I'm concerned.
Now, final point, and with one response from someone, as you know, and I agree with you, the framers of the Constitution, they were brilliant people, and they were flawed. God, were they flawed. But they were brilliant. And they did give us a means by which a president can be checked if we have the will to do it. The way is available to us. So the efficacy of the way is challenged by the fact that the will doesn't appear to be there to exercise the opportunities available in the Constitution. Who knows of what I speak?
Well, you're speaking, of course, directly not just to the power of the purse, but ultimately mechanisms for removal.
That's right. Impeachment. It's there. The question is, do we have the will? The way is there. The constitutional violations are many, target-rich environment. Just a question of when will we get the will to do what the way provides. Mr. Chairman, thank you so much. I yield back.
Thank you so much. The gentleman yields back. Let me say to the witnesses, you all have been excellent. We see a lot of people before us. You are very prepared on the subject matter, both professionally and from an experience standpoint. And I think the concerns that some of us are having is the technology framework is out ahead of any oversight or regulation. And I don't know how you put the genie back in the bottle at this point, but I think Congress is going to be forced to do something. And part of it is holding hearings like this to elevate the view on more people. Ms. Cleland, you are, and this committee is man a true patriot, because not only were you violated as an American citizen, but you had the strength to come and tell your story to this committee. And it's those kinds of stories that allow us to say we're a better country than this. But it's only with this experience. And I say, since we've had this hearing, this administration has said that any state that does not provide voter registration data, they will not be allowed to do mail-in voter registration requests in their states. So all of a sudden, a law that's questionable is being pushed out by the executive branch that adversely impact a Secretary of State who's saying, no, you don't have access to my voting roll, it's my role. And so that's being carried to the next level. And so there are things being done by the executive branch for which there's no valid legal posture for them to do it, other than I'm president and I do what I want to. And that's more than just a slippery slope. That's the flashing red light that I think we all should be cautioned. The other comment that was made relative to documenting oversight, well, on February 27th, every Democratic member of this committee sent a letter to DHS asking for documentation on certain aspect of surveillance. And as of this date, we've not received an acknowledgement or a response from that. So oversight is still being ignored by this department. And so this shadow hearing is a byproduct of the lack of oversight by this administration. But Democrats on the committee are committed to doing that rigorous oversight, even if it is in a shadow hearing form, because the public has a right to know. And I believe our witnesses, though not under oath, have told us the truth. And we dare our Republican colleagues to bring those same witnesses before the full committee under oath. And I believe the testimony that we heard here today will in fact be the same testimony that you will give before the full committee. So hearing no disagreement on what you would say, we readily invite the chair of the committee to convene a hearing on this subject. We'll give him this body of witnesses, but he want other witnesses. You know, that's the process. But this is how democracy should work, rather than how it's working today, and that's not the way. So let me thank our witnesses for your valuable testimony and the members for their questions. Hearing no further business, the hearing stands adjourned.
Tonight, Republican and Democratic members of Congress take part in the annual Congressional Baseball Game, a bipartisan